an exploration of Article 9, detailing the creation, perfection, and enforcement of security interests in personal property. Chapter Key Points. Article 9 of the UCC governs secured transactions, providing a framework for security interests. Understanding the creation of security interests is crucial for lenders and borrowers. Perfection of security interests ensures priority over competing claims. Priority rules determine the order of claims in case of default. Secured parties have specific rights and remedies upon default, including repossession. 5.1. Introduction to secured transactions. Secured transactions are a fundamental aspect of commercial law, particularly in the realm of lending and borrowing. At the heart of these transactions is Article 9 of the Uniform Commercial Code, U.C.C., which provides a comprehensive framework for the creation, perfection, and enforcement of security interests in personal property. This section will introduce you to the significance of Article 9, its role in commercial transactions, and the various types of transactions it covers. To understand secured transactions, it's essential to grasp what a security interest is. A security interest is a legal claim on collateral that a borrower offers to a lender to secure a loan. For example, if you take out a car loan, the lender may require you to pledge the vehicle as collateral. This means that if you fail to repay the loan, the lender has the right to repossess the car. Article 9 is significant because it establishes the rules that govern these security interests. It outlines how lenders can create a security interest, how they can perfect it to ensure priority over other claims, and what rights they have if a borrower defaults. Understanding these concepts is crucial for both lenders and borrowers to navigate the complexities of commercial transactions. One of the key components of Article 9 is the process of perfection. Perfection is the legal process that makes a security interest enforceable against third parties. For instance, if a lender perfects their security interest in a vehicle by filing a financing statement with the appropriate state authority, they gain priority over other creditors who may have claims against the borrower. This means that in the event of default, the perfected lender has the first right to repossess the vehicle. Additionally, Article 9 includes priority rules that determine the order of claims in case of default. For example, if a borrower has multiple loans secured by the same collateral, the order in which those loans were perfected will dictate which lender gets paid first. This is crucial for lenders to understand, as it affects their risk and potential recovery in the event of a borrower's insolvency. Finally, secured parties, those who hold a security interest, have specific rights and remedies upon default. These can include the right to repossess the collateral, sell it, and apply the proceeds to the outstanding debt. For example, if a borrower defaults on a loan secured by equipment, the lender can take possession of that equipment, sell it, and use the money to pay off the loan. In summary, Article 9 of the UCC plays a vital role in facilitating secured transactions by providing a clear legal framework for security interests. Understanding its provisions is essential for anyone involved in commercial lending or borrowing, as it helps ensure that both parties are aware of their rights and obligations. As we delve deeper into this chapter, we will explore the intricacies of creating, perfecting, and enforcing security interests in personal property. Section Summary. Article 9 of the UCC governs secured transactions, providing a framework for security interests. Understanding the creation of security interests is crucial for lenders and borrowers. Perfection of security interests ensures priority over competing claims. Priority rules determine the order of claims in case of default. Secured parties have specific rights and remedies upon default, including repossession. 5.2. Creation of security interests. Creating a security interest is a critical step in secured transactions, as it establishes a legal claim on collateral that a borrower offers to a lender. To understand how security interests are created, we need to explore two key concepts: attachment and enforceability. Attachment is the first step in creating a security interest. For a security interest to attach, three requirements must be met. 1. Value. The lender must give value to the borrower. This can be in the form of cash, a loan, or other consideration. For example, if you take out a $10,000 loan to buy a car, the bank provides value by giving you the money. 2. Debtor's rights in the collateral. The borrower must have rights in the collateral that is being pledged. This means that the borrower must own the collateral or have the authority to grant a security interest in it. For instance, if you own a car, you can pledge it as collateral for a loan. 3. Security agreement. There must be a security agreement that describes the collateral and is signed by the borrower. This agreement can be a formal document or even a simple email, as long as it clearly outlines the terms. For example, a bank may provide a security agreement that states, the borrower pledges the 2020 Honda Civic as collateral for the $10,000 loan. Once these three requirements are satisfied, the security interest is considered to have attached, meaning the lender now has a legal claim on the collateral. Enforceability is the next step, which ensures that the security interest is enforceable against third parties. To be enforceable, the security interest must be perfected. Perfection typically involves filing a financing statement with the appropriate state authority, which publicly records the lender's interest in the collateral. For instance, if the lender files a financing statement for the car loan, it puts other potential creditors on notice that the bank has a claim to the vehicle. In summary, the creation of security interests involves a clear understanding of attachment and enforceability. By ensuring that value is given, the borrower has rights in the collateral, and a security agreement is in place, lenders can secure their interests effectively. Additionally, by perfecting the security interest through filing, they can protect their claims against other creditors. This process is essential for both lenders and borrowers to navigate the complexities of secured transactions successfully. Section Summary. Creation of a security interest involves attachment and enforceability. Attachment requires value, debtor's rights in the collateral, and a security agreement. Enforceability ensures the security interest is recognized against third parties. Perfection typically involves filing a financing statement. Understanding these concepts is crucial for successful secured transactions. 5.3. Perfection of security interests. The perfection of security interests is a crucial aspect of secured transactions, as it establishes the priority of a lender's claim over the collateral in the event of a borrower's default. In this section, we will explore the three primary methods of perfecting security interests: filing, possession, and control. Each method has its own advantages and is applicable in different scenarios. 1. Filing. The most common method of perfecting a security interest is by filing a financing statement with the appropriate state authority, typically the Secretary of State's office. This statement serves as public notice of the lender's interest in the collateral. For example, if a business takes out a loan secured by its inventory, the lender will file a financing statement that includes details about the collateral and the parties involved. This filing puts other potential creditors on notice that the lender has a claim on the inventory. Filing is generally preferred because it is a relatively straightforward process and provides a clear record of the security interest. However, it is important to ensure that the financing statement is filed correctly and within the required time frame to maintain priority over other claims. Possession. Another method of perfection is through possession of the collateral. This is particularly relevant for tangible personal property, such as equipment or inventory. When a lender takes possession of the collateral, they automatically perfect their security interest without the need for filing. For instance, if a lender provides a loan to a borrower and takes possession of the borrower's machinery as collateral, the lender's interest is perfected simply by having the machinery in their control. Possession can be advantageous because it provides the lender with immediate control over the collateral, reducing the risk of loss. However, it may not always be practical or possible for lenders to take possession of certain types of collateral, such as inventory that the borrower needs to operate their business. Control. The third method of perfection is through control, which is primarily applicable to certain types of the collateral, such as deposit accounts, investment property, and electronic chattel paper. Control means that the secured party has the ability to direct the disposition of the collateral. For example, if a borrower has a bank account that serves as collateral for a loan, the lender can perfect their security interest by obtaining control over the account, often by having the bank acknowledge the lender's security interest. Control provides a strong level of security for lenders, as it ensures that they can access the collateral without relying on the borrower. However, like possession, control may not be available for all types of collateral. In summary, the perfection of security interests is essential for establishing priority and protecting a lender's rights in the event of default. By understanding the methods of filing, possession, and control, both lenders and borrowers can navigate secured transactions more effectively. Each method has its own benefits and limitations, and the choice of method will depend on the specific circumstances of the transaction and the type of collateral involved. Section Summary. Perfection of security interests establishes priority over collateral in case of default. Filing a financing statement is the most common method of perfection. Filing provides public notice of the lender's interest in the collateral. Possession of collateral automatically perfects the security interest. Control is applicable for certain types of collateral, such as deposit accounts. 5.4. Priority of security interests. The priority of security interests is a fundamental concept in secured transactions, particularly under Article 9 of the U.C.C. Understanding how priority works is essential for both lenders and borrowers, as it determines who gets paid first in the event of a default. This section will delve into the priority rules governing competing security interests, the effects of perfection, and the important principle of first in time. The concept of priority. In the world of secured transactions, priority refers to the order in which creditors can claim the collateral in case the borrower defaults on their obligations. When multiple creditors have security interests in the same collateral, the priority rules dictate which creditor has the first right to the collateral. Generally, the rule is that the first creditor to perfect their security interest has priority over others. This is often referred to as the first-in-time, first-in-right principle. 2. Effects of perfection. Perfection is the process that establishes a secured party's interest in collateral against third parties. As discussed in the previous section, perfection can be achieved through filing, possession, or control. Once a security interest is perfected, it becomes enforceable against other creditors and establishes priority. For example, if lender A files a financing statement for a security interest in a borrower's equipment on January 1st, and lender B files a similar statement for the same equipment on February 1st, lender A will have priority over lender B because they perfected their interest first. Competing security interests. Consider a scenario where a borrower takes out two loans, one from lender A secured by their inventory and another from lender B secured by the same inventory. If lender A perfected their security interest by filing a financing statement before lender B, lender A has priority. In the event of the borrower's default, lender A can claim the inventory before lender B can make any claims. However, if lender B had perfected their interest first, they would have the priority instead. 4. Exceptions to the priority rules. While the first-in-time rule is the general guideline, there are exceptions. For instance, certain types of security interests, such as purchase money security interests, PMSIs, can take priority over previously perfected interests if specific conditions are met. A PMSI occurs when a lender provides financing for a borrower to acquire collateral, and if the lender perfects their interest within a certain time frame, they can gain priority over other creditors who may have a prior interest in the same collateral. Conclusion. Understanding the priority of security interests is crucial for anyone involved in secured transactions. It not only affects the rights of creditors, but also impacts the borrower's ability to secure financing. By grasping the concepts of perfection and the first-in-time principle, both lenders and borrowers can navigate the complexities of secured transactions more effectively, ensuring that their interests are protected in the event of default. Section Summary. Priority of security interests determines the order of claims in case of default. The first-in-time, first-in-right principle establishes priority among creditors. Perfection of a security interest is essential for enforcing claims against third parties. Competing security interests can arise when multiple creditors claim the same collateral. Exceptions to priority rules exist, such as purchase money security interests, PMSIs. 5.5. Enforcement of security interests. In the realm of secured transactions, the enforcement of security interests is a critical aspect that comes into play when a borrower defaults on their obligations. This section will explore the rights and remedies available to secured parties, including the processes of repossession and foreclosure, providing a clear understanding for beginners. Understanding default. Default occurs when a borrower fails to meet the terms of their loan agreement, such as missing payments or violating other conditions. For instance, if a business owner takes out a loan secured by their equipment but fails to make payments, they are in default. 2. Rights of secured parties. Upon default, secured parties, typically lenders, have specific rights to protect their interests. These rights include repossession. This is the process by which a secured party takes back the collateral without going through the courts. For example, if a borrower has financed a car and defaults on the loan, the lender can repossess the vehicle. This is often done without prior notice, as long as it is done peacefully and does not breach the peace. Foreclosure. This is a legal process that allows a lender to take possession of real property, like a house, when the borrower defaults on a mortgage. In a foreclosure, the lender must follow specific legal procedures, which may vary by state. For instance, if a homeowner defaults on their mortgage, the lender may initiate foreclosure proceedings to sell the property and recover the owed amount. 3. The repossession process. The repossession process typically involves the following steps. Notice of default. The lender usually sends a notice to the borrower indicating that they are in default and may face repossession. Repossession. If the borrower does not remedy the default, the lender can proceed with repossession. For example, a bank may send a tow truck to reclaim a car parked in the borrower's driveway. Sale of collateral. After repossession, the lender may sell the collateral to recover the outstanding debt. If the sale price exceeds the debt, the borrower may receive the surplus. If it is less, the borrower may still owe the difference. 4. The foreclosure process. The foreclosure process generally includes filing a lawsuit. The lender must file a lawsuit against the borrower to initiate foreclosure proceedings. Court hearing. A court hearing may be held where both parties can present their case. If the court rules in favor of the lender, it will issue a judgment allowing the lender to proceed with foreclosure. Auction of property. The property is typically sold at a public auction, with the proceeds going to pay off the debt. For example, if a homeowner owes $200,000 on their mortgage and the property sells for $250,000 at auction, the lender will recover the owed amount and the homeowner may receive the remaining $50,000. 5. Conclusion. Understanding the enforcement of security interests is essential for both lenders and borrowers. Secured parties have specific rights to repossess or foreclose on collateral upon default, which helps them mitigate losses. For borrowers, being aware of these processes can help them navigate their obligations and avoid defaulting on their loans. By grasping these concepts, individuals can better understand their rights and responsibilities in secured transactions. Section Summary. Default occurs when a borrower fails to meet loan obligations. Secured parties have rights to repossess or foreclose on collateral upon default. Repossession can occur without court involvement if done peacefully. Foreclosure is a legal process requiring court procedures to reclaim real property. Understanding these processes is crucial for both lenders and borrowers. 5.6. Default and remedies. In the context